When a contract is breached, the law provides specific remedies to help the harmed party. But what exactly is a legal remedy? Simply put, it's the solution the law offers to someone who suffers harm because another party failed to keep their contractual promise. These remedies ensure that contracts are meaningful and enforceable, giving parties confidence that their agreements will be respected. Without remedies, there would be little incentive for anyone to honor their commitments. The type and extent of the breach play a big role in determining which remedies are available. In this video, we'll explore the main categories of remedies, when and why they are used, and how to choose the most appropriate one for each situation. Remedies for breach of contract fall into three main categories: enforcing the contract, canceling the contract, and compensating for damages. Enforcement means making sure the contract is carried out as agreed, often through a court order for specific performance, an interdict to stop certain actions, or by allowing the innocent party to withhold their own performance. Cancellation, on the other hand, ends the contract, usually when the breach is serious or material. Finally, compensation involves awarding damages to the harmed party to cover their losses. Sometimes, contracts include penalty clauses that set out in advance what must be paid if there's a breach. Understanding these options is key to knowing how to respond when things go wrong in a contractual relationship. Selecting the right remedy depends on the circumstances of the breach. Courts consider factors like the seriousness of the breach, whether performance is still possible, and the impact on both parties. For example, a court may refuse to order specific performance if it would cause undue hardship or if performance has become impossible. Sometimes, the harmed party can choose between canceling the contract or seeking damages, but not both at the same time. It's also important to note that the harmed party must try to minimize their losses, a principle known as mitigation. In some cases, a prohibitory interdict can be used to prevent a breach before it happens. By understanding these principles, parties can make informed decisions about how to protect their interests when a contract is broken. Damages are a central concept in contract law. They are meant to put the harmed party in the financial position they would have been in if the contract had been properly performed. There's a difference between contractual damages, which arise from a breach, and delictual damages, which result from wrongful acts outside of a contract. Penalty clauses, meanwhile, are pre-agreed terms in a contract that specify what must be paid if a breach occurs, making it easier to prove losses. However, a harmed party cannot claim both damages and a penalty for the same breach. Understanding these distinctions helps parties know what to expect and how to structure their contracts for better protection. Summary: remedies for breach of contract are essential tools for upholding agreements and ensuring fairness. Whether you're enforcing a contract, canceling it, or seeking compensation, it's important to understand the legal requirements and practical considerations involved. Always assess the seriousness of the breach, consider the available remedies, and remember your duty to mitigate losses. If you're drafting a contract, think about including clear penalty and cancellation clauses to make future disputes easier to resolve. By being informed and proactive, you can better protect your rights and interests in any contractual relationship.